Hello everyone, we have to discuss about that prelims Baba ka. The burgeoning expenditures of elections content. According to the Center for the Media's Study (CMC), the total expenditures by various political parties and for the general elections to the Lok Sabha this year was around and 1 lakh crores. And background urgent reforms and are needed to address the burgeoning cost of election expenditures, and which is the thrown foundationals and principles of democracy. Key and takeaway. What are the limits in India? The election expenditures limits for the candidates is the 95 lakhs and per Lok Sabha, and consistency in the larger state and the 75 lakhs in the smaller state, and with respect to the legislative assembly, and they are the 40 lakhs and the 28 lakhs, and for the for larger and smaller state respectively. Thus limits are set and from time to time and by the election commissions, and there are no limits and on the expenditures of political parties during election. What are the international standards? In the US, the financials and for the elections happen primarily by the contributions from individuals and corporations and political section community PAC. Out of the estimated expenditures in the November 2024 and election cycles, around 5.5 millions is the estimated to be the spent on the presidential elections. This humongous and raise is due to the large donation in the UK. The political parties is around to spend the 54,010 and for each the consistency they contest, and there are also limits and places on the candidates expendings during the competition. It's the translators and per the consistency and to and the average of 46 and 49 thousands, and during the long campaigns period beginnings and 5 months and before the full end terms of the House of the Common ends at the 17 and 20 thousands during the short campaign periods after the elections are announced. What are the challenges? Such and the increased expenditures that is made primarily and through the large and donations creates and the unholy nexus in between are the elected representatives and donors, and this also the acts and as and the entry barrier into the electoral political sphere. Many well-meaning and citizens in India's candidate and from all major political parties breach the election expenditures limit. Further, there are no limits on the political parties expending during elections. The official expenditures declared by the BJP and the Congress and for the 2019 election were 164 crores and 820 crores and respectively. However, according to other reports and by the CMS, and 50,000 crores was expended and by the various parties during the 2019 election. The CMS and has the estimated and that the expendings during the 2024 election by various political parties was close to the 10,000 1 lakhs and crores, and such the inflated and election expenditures fuels corruptions resulting in other cycle in the various vicious cycles. What can be possible reforms? The Indrajit and Gupta Community 1998 and the Law Commission's report 1999 and has advocates to states funding of elections and certain practicals steps to create other levels payings and field the regarding election expenditures can be impacted. Thus are the based on the EC 2016 and report on proposals electoral reforms. First, the laws and must be the amended to explicitly and provided that the financial assessment and by other political parties to its the candidate should also be the within the candidates and prescribes an election expenditures limit. And secondly, there should be other ceilings on political parties expenditures, and this may be kept at not and more than the expenditure ceilings limits provided 4a, the candidates multiplies and y, the numbers of candidates of the parties and contesting the election. Finally, additionally, judge and may be the appointed in high courts and for the speeding disposals of election related cases, and which could and act as other determined against the violating those norms. Articles 44. Contact. Content and Union Home Minister Amit Shah recently said that the tribals and would be the exempted and from the Union Civil Code and UCC and wherever and it is the implemented in India background. It and the event in Ranchi and Home Minister started the BJP has introduced a models of the Uniform Civil Code and UCC in Uttarakhand. In the models and we have included tribals respectively their customs, rituals and laws, and wherever we impacted the UCC and tribals and will be the kept out of its scopes. Key takeaway: a uniform civil code is one and that would be provided and for one laws and for the entire country, applicable to all religions and communities in there the personal matters and such as the marriage, divorce and inheritance, adoptions, etc. Article 44 of the Constitution law down that the state shall endeavor to secures the uniform civil code for the citizens throughout the territories of India. Articles 44 is one of the directive principles and thus is the defined in Articles 37 are not and the justiciables and not and the enforceables by any the court and but the principles and laid down therein and are the fundamentals in government. Articles 44 uses the words and states shall the indigenous and others the articles in the directive principle chapter and use words and such as in the particulars and strip and shall in the particulars direct its the policy and shall be the obligations of the state, etc. Article 43 mentions and state shall indigenous by the suitable legislations and while the fairs and by the suitables and legislative is absent in Article 44. All this implies that the duties of the state is the greater in others the directive principles than in Article 44. Uniform Civil Code UCC of Uttarakhand. The UCC of Uttarakhand enacted in early in 2024 aimed to the standardize personals and laws across the state and irrespectively of religious affiliations and key features includes marriage and divorce. The UCC and includes uniform procedures for marriage and divorce and providing practices like the polygamies and child marriages and it is set other consistent minimums and marriageable age for girls across all religions and denominations. Inheritance and property rights. The code and ensures equal property right and for sons and daughters, eliminating distinctions between the legitimate and illegitimate children and concerning inheritance. It also provided equal properties and rights after the death, including for adopted and biological children. Live in relationship. The UCC and regulates live in relationship by the imposing and the obligations to register them. Applicability is the code applied and to all the residents of Uttarakhand expected the scheduled tribes. Contact. In a letters to the Lok Sabha speakers and some the opposition's members of the Joint Committee of Parliament and on the BAQF amendment and bill have and trained to the disassociate and from the panels assuring its the chairpersons and BGP leaders. Jagadambika Pal of the Bull dozings the proceedings and the stone wailings them. Background. In India, the history of the Waqf can be tracked back to the early days of the Delhi Sultanate when the Sultan Muhammad Majuddin Sham Gaur dedicated two villages in favor of the Jama Masjid of Multan as the Delhi Sultanate and later Islamic dynasty flourished in India. The numbers of the Waqf and properties kept increasing in India. And key takeaway. Waqf refers to properties and dedicated inclusively and for the religious or the charitable purposes under the Islamic laws, and any others the use or the sale of the properties is prohibited, and Waqf means that the overseed of the properties is now and taken away from the persons and taking Waqf and transferred and detained by Allah. Waqif is the person who created the Waqf for the beneficiaries, and as Waqf the properties are the bestowed upon Allah in the absence of other physically and tangible entry. A. The Mutawali is appointed by the Waqif or by the competent authorities to manage or the administers a Waqf. Once designed as the Waqf, the ownership is transferred from the persons making the Waqf and Waqif to Allah, and making it is the irrevocable. India has had other legal regimes for the government of Waqf since 1913, when the Muslim Waqfs and Validating Act come into force, and Musalman and the Waqf Act 1923 and followed. And after the independence, the Central Waqf Act 1954 was enacted, which was ultimately replaced by the Waqf Act 1995 in 2023. In 2013, the law was amended to prescribe the imprisonment of US up to 2 years and for the encroachment on the Waqf property, and to explicitly and prohibit the sale, gift, exchange, mortgage or the transfer of Waqf. The Waqf laws provided for the appointed of other survey commissioners and who maintain other list of all Waqf properties by making the local investigations and summaries, witness and requesting public documents. A Waqf property is managed by other Bali and caretakers and who act as other supervisors. Waqf property are managed in other way that is similar to how properties under the trust are managed under the Indian Trust Act 1882. The Waqf Act states that any the disputes related to Waqf property will be decided by the Waqf tribunal. The tribunal is constituted by the state government and comprises 3 the member persons. A chairperson who is the state judiciary officers. The tribunal is constituted by the state government and comprises 3 members. The chairperson who is the state judiciary officers not below the rank of the district session all civil judges classes first, and the officers and from the state civil services, and other person with knowledge of Muslim laws and the jurisprudence. The Waqf Amendment Bill 2024, it is changes the compositions of the Central Waqf and Council and Waqf Board to includes non-Muslims members. The survey commissioners has been replaced by the collectors and granting him powers to conduct survey of Waqf properties. Government properties identified as Waqf will case to be the Waqf collectors and will determines ownerships of such properties and finalities of the tribunal's decisions and has been revoked. The bill provided for the direct appeals to the High Court. New Coastal Zone Plan of Kerala. Contact. The Union Ministry of Environment, Forest and Climate Changes has approved the Coastal Zones Management Plan and CZMPS of 10 and coastal districts of Kerala. Background. The plan and prepared in the tunes with the provisions of the Coastal Regulations and Zone Notification 2019 permits the coastal district to take advantage of relaxation coastal regulations, zone and CRZ rules and the initiative development activities including the constructions of building towards the seaward sides. And key takeaway. A coastal zone management plan and CZMP is other frameworks and designed to the regulates and manage activities within the coastal areas to the balance environmental and conservations with sustainable development. In India, the Ministry of the Government, Forest and Climate Changes (MOEF) and CC issues the coastal regulations zone (CRZ) notifications is 2019, which is mandate the preparations of CZMPS by the coastal state and union territories. Key objectives of the CZMPS: environmental conservations project economically and sensitive areas such as the mangroves and coral reefs and wildlife habitat, and sustainable development promotes development and activities and that do not and the comprises the health of the coastal ecosystems and livelihood security and safeguard the interest and the traditional right of coastal communities include the fisher folk. Components of the CZMP: demarcations of the coastal zones, the identification and classification of coastal areas into the different and zones, and CRZ, CRZ1, CRZ2, CRZ3, CRZ4 regularity measures, establishment of the guidelines and the restrictions for the permissibles and activities and within the each zones to prevent the environmental degradations and management strategies, and the development of plans and for the pollutions controls, disasters management and conservations of coastal and marine resources. And what does it mean for the Kerala's the 2011 census and put the populations densities of Kerala's at 8 and 59 persons per square kilometer, and which is the more than the doubts and the nationals and average of 382 and persons and per the square kilometer. The coastal areas of the states are marked by the high densities of the populations when compared to other parts of the state. The high and the demographics and pressures on land had and resulted in the rampant and violations of the CRZ rules along the coast. The focus of the CRZ 2011 regime, which was in the force until the approvals of the CZMP, and was on the conservations of the coastal ecosystem, which is turn protected and the livelihood of the missions of fishers and coastal communities. What are the benefits? What are the benefits? The approvals of the CZMP and would the directly benefits around the 10 lakhs pupils, and according to and the estimated of the state government as the earlier restrictions and for the constructions of new houses and repairs of existing homes and will be the relaxed. The new and regimes and will see the no and development zone and NDZ, the areas and which has to be the left and untouchable touched around the tidals influence water bodies reducted. And what about and mangroves? Vast trust of the mangroves vegetation would be exposed to exploitations as the 2019 notifications has limited the legals and protections of government holding of and the extend overs 1000 square meters to 15 and meters and buffer zones. The new and regimes has also taken away the mandatory buffer zones and around the mangrove vegetation locations in private holdings. Not all private properties can be taken over by the state. Not all private properties can be taken all over by the state. Contact in the landmarks of the rulings that has the implications on the citizens and right to the hold properties. A 9-judge bench and of the Supreme Court and ruled that not and all the private properties and can be the deemed and materials resources of the community and for the redistrictions and under the Articles 39 and B of the Constitution's background. Falling under and Part 4 and of the Constitution's titles Directive Principle of the State Policy DPSP Articles 39 being placed and the obligations on the states to create the policy towards securing the ownerships and controls of the material resources of the community are so the distributed as best to the subbed and the common good. Key takeaway: the rulings in the constitutionals and the references essentials undowns and severages several and decades of the Supreme Court and the jurisdictions on the issues, and a line of the judgment and holding that the both public and the private resources and fail within the ambit of material resources of the community and under the article 39b and stem from other minorities and opinions by the Justice B.R. and Krishna's lawyer in the state of the Karnataka and V. the Shri and the Rang Nathana and Reddy in 1977. A 1982 and 5 judges constitution bench and ruling in the case and Sanjeev Coke and manufacturing companies as Bharat Cooking Coal Limiteds and had the affirmed justice and layers and views. The majority's opinions of the SCN has now the disagreed and with thus and the judgment. It is said the justice and liars cast and the net wide and the holdings that all the resources and which meat and the materials need are the covered by the fairness and any the attempts and by the government to the nationalized and thus the resources and would be the within the scopes and of article 39b. SC Supreme Court aided in the essence the interpretations of articles 39b and adopted in thus and the judgment is rooted in other particulars economics and ideology and the relief that and the economics and structures and which is the prioritize the acquisitions of private properties and why the state is beneficiaries and for the nations. As per the recent judgment, the text of the provisions and indicates that not all the property and owners and resources fell within the ambit of the place and how weavers and privately and owners resources are not excluded as other class and some the private resources may be the covered and the code edited that the Ranganath Reddy and Sanjeev Coke judgment and are the incorrect and to the extended that they hold that all resources of of an individuals are the parts of the communities and thus all the private properties is covered by the ferrous materials and resources of the communities. The majority opinions reference to India's economic growth and the trajectory. The mixed economic of 1950 and 1960 and that the includes heavy the industries and the impact and the mixed economic of 1950 and 60 included heavy industries and import substitutions, the shift towards the property. Socialist reform in the late 1916 and the 90s and followed by the market-based reform in 1919 of the liberalization's years. Positive secularism. Contact the Supreme Court in the Arjunas and the Kadri and the Ans and Wells, the unions of the Indias and the Ors and upheld the consistency of the UP and the Madras Act 2004. The Allahabad High Court had declared the UP and the Madras Educations and Board Act and the constitutionals on March 2020 and this year. Key and the takeaway: the SC and the Supreme Court and did not agree and with the High Courts and decisions to strike down the Madras Act based on the secularism as a part of the basic structures. Citing it's the Indira Nehru Gandhi judgment 1975, the Supreme Court and categorized hold that the doctrines of basic structure should be the involved to the examine the verities of other constitutional amendment, not and the ordinary piece of legislations like the UP Madras Act. The current judgments authorized by the CJI and Chandrachud and hold that in the testings, an ordinary law court and should look just at the legislative competented and the consistency with the fundamentals right and the judgment and accordingly and the observed and that and the ordinary law cannot be the declared and the unconstitutional for the violating the basic structures of the constitutions and because the concept such as the democracy and the federals and the secularism are the undefined, and permitting courts to strike down legislations for their the vocations of such concept, and with the introduced an element of uncertainty in the adjudications. The SC said in its the present and verdict act that articles 25 to 13 and contain the other facts of the secularism, that is the practice of religious and tolerated by the state, and it is observed that by the recognizing and regulations the madrasas educations, the state legislations is taking the positives and actions to safeguard the educational right of the minorities, and judgment also the said in the essence, and that the secularism is other faced of equalities. It is the rightly observed that the substantive equalities and shall remains and the illusions unless the states is the possibly charges and within the duties to provide the equal treatment to all the persons and irrespectively of their religions, faith or belief. The court recalled its the leading judgment on Articles 13 to explain the extent of state control of majorities institutions in the name of regulations. It is the clarified that the majority character of and the institution cannot be the annihilated or the destroyed, and certainly and minorities do not have the right to aid and affiliations or recognitions of degrees. However, at the same time, and neither add or nor and the affiliations or nor the recognizations by the state can the come with such and the additions and that would and the destroy and the institutional minority and characters, and madras and are the entitled to state protections under articles 26, and which gives the religious and dominations denominations or any the sections theirs of the rights to the established and the maintain the institutions for the religious and characterized and purposes. Thus the purely religious institution can legislatively to establish and the maintained sanctions needed under the PMLA to the prosecutors and public servants. The Supreme Court recently held that the Section 1971 one of the Code of the Criminal Procedures and CRPC that the mandate provides prioritized sections from the government to take the cognized of and the offence against the public servants and will apply to the prevent of the money lendings and act the PMLA to background. The Supreme Court said his the whiles and upholdings the Telangana High Court and decision setting aside a tribe courts under the taking recognitions of the complaints against the IAS officers and facing money laundering. Key takeaway. Section 197A says, when any the person who is or the was are the judges or the magistrates or the public servant not the revocals from his the office and save by or the with the sections of the government is accused of any the offence and the alleged and to have been and committed and by his the whilst actings or the purportings and to the act in the discharges of his the official's duty. No court shall take or cognized of such the offence expected with the previous sections. The ruling pointed out and that the section 65 of the PMLA and makes the provisions of CRPC applications to all the proceedings and under the PMLA and the provide the same are and not the inconsistent and with the PMLA providing the additional information. PMLA laws down the stringent and the standard for the granting walls, and section 45 of the PMLA is the negatives and provides provisions and which was the court and from the granting walls unless the accused can provide that there is no the prima and facie case against themes and that and they will not committed any the offence in the future. The first and challenges to the PMLA was against the alternate and criminal laws and after systems and that the PMLA created. Since the ED is the kept and outside the purview of the Code of the Criminal Procedures and CRPC, the ED is not the considered police and hence does not and follow the provisions of CRPC and for the searches and seizures and arrested and attachment of properties. National Legal Service Day. National Legal Service Day is observed in India every year on November 9 and Articles 39A and of the Constitution of India. It is provided that the state shall secure and that the operation of the legal system and promotes the justice on the basis of equal opportunities and shall in the particulars provided free and legal aids by the statutes and the legislations or schemes or in any and the other ways to ensure that the properties and for the securing justice are not and defined to any the citizens by the reasons of the economics or other and the disabilities. Key takeaway. The Supreme Court of India established National Legal Service Day in 1955 and to provided the free legal assessment and supports to the society most the vulnerable sections. It is aims to bridge the gap and between the law and pupils is greatest need and through the variety of the activities organized by the NALSA and others the legal entails including legal awareness programs and workshops and camps. In 1987, an Legal Services Authorized Act was enacted and to give other statutory base to the legal aid program throughout the country or on other uniforms patterns and this the act and was the finally enforced. And on the 9th of the November 1995 after the certain amendment and bear the introduced and therein by the Amendment Act of the 1994. National Legal Service authorized NALSA. The NALSA has been the constitutes and under the Legal Service Authority Act 1987 to provide the free and the legal services to the weaker section of the society. It is organized Lok and Adalat and for the amicable and settlements of disputes. It is also the monitors and the reviews various legal aids and programs and provided the rules and principles for legal services under the act. It is also distributes fundings and grant to state the legal services authority and non-profits organizations to help them the acute legal aid systems and initiatives. Honorable Chief Justice of India is the Pro-in-Chief and the NALSA is houses at the Supreme Court of India. Legal is a state legal service and the authority SLSA and the District's Legal Service Authority DLSA. The SLSA is established in every state too. Implement and NALSA's policies and provide free legal services including the Lok Adalat. The SALSAs is headed by the humble Chief Justice of respectively High Court and who is the in the Chief of the State Legislation's Legal Service Authority. Similarly, in every district and the DALSAs has been the constituted and to implement legal services program in the districts. The DALSAs is chairpersons by the district's judge of the respectively directors and is situated in the district's court complex in every district who is eligible for getting free and legal services. Under Sections 12 of the Legal Service Authority Act, every person who has to find or the defense as the case shall be entitled to legal services under this act if that person is women and children, member of the SC and ST, industrials, women, men, victims of the mass disaster, violence, flood, drought, earthquake, industrial disasters, disabled person in custody. If that person is related to the sections of the Juveniles and Justice Act 1986 and 53 of the 1986 or in other physiatrics and the hospitals or the physiatrics nursing home and within the meanings of clause of section 2nd of the Mental Health Act of 1987, 14 of the 1982. Those persons who have the annual income of less than the amount and prescribed by the respectively state government. If the case is before any the court and others and then the Supreme Court and less than the 5 lakhs if case is before the Supreme Court and victims of the trafficking in human beings or beggars. Control adoptions. Controls adoptions resource authority, Kara.